In this one, we are discussing example number 2, and that relates to the chapter that is the meeting of board and its power. Example 2 क्या बोलता है, जो board of directors है of Infotech Consultant Limited. हम क्या बोलते हैं, what does this example talks about? Basically, that is the board of directors है of Infotech Consultant Limited के were registered हुए in Kolkata. They proposes to hold the board next board meeting in the month of May 2019. जो बीओडी है इन्फोटेक कंसल्टेंट लिमिटेड के, जो कि रजिस्टर्ड है कोलकाता में, वो प्रपोज कर रहे हैं कि वो होल्ड करेंगे नेक्स्ट बोर्ड मीटिंग इन द मंथ ऑफ May 19. इट वाज डिसाइडेड टू होल्ड द बोर्ड मीटिंग इन चेन्नई थ्रू वीडियो कॉन्फ्रेंसिंग. फिर उन्होंने डिसाइड किया कि बोर्ड मीटिंग को क्या करें कि वीडियो कॉन्फ्रेंसिंग के थ्रू ही कर लेते हैं. थ्रू ऑल द डायरेक्टर्स ऑफ द कंपनी डिसाइडेड कोलकाता, क्योंकि सारे जने जो है सारे के सारे कोलकाता में रहते हैं. As a provision in the Companies Act 2013 does not require that the board meeting must be held at a particular place. तो प्रोविजन के अकॉर्डिंग तो जरूरी नहीं है कि एक पर्टिकुलर प्लेस पे ही हो. अकॉर्डिंगली देयर इज नो डिफिकल्टी इन होल्डिंग द करंट बोर्ड मीटिंग एट ए चेन्नई थ्रू वीडियो कॉन्फ्रेंसिंग से कर ले तो कोई प्रॉब्लम वाली बात नहीं. इवन इफ ऑल द डायरेक्टर्स ऑफ द कंपनी रिसाइडेड कोलकाता एंड द रजिस्टर्ड ऑफिस इज ऑल्सो, सारे जने कोलकाता में रहते हैं, रजिस्टर्ड ऑफिस भी कोलकाता में है. हाउएवर it is to be seen that the legal requirement as prescribed, जो भी legal requirement under section 173 subsection 2 and rule 3 of the company's meeting of board and its power rule 2014 are meticulously followed. उसके बाद आता है हमारा then next comes that is the नेक्स्ट आता है XYZ लिमिटेड, जो है एक फॉरेन कोलैबोरेटर है इन एबीसी लिमिटेड में इनकॉर्पोरेट हुई इन इंडिया अंडर द कंपनीज एक्ट 2013. जो फॉरेन कोलैबोरेटर है वो होल्ड कर रहे हैं 49% ऑफ द शेयर होल्डिंग. द बोर्ड मीटिंग ऑफ एबीसी लिमिटेड आर यूजुअली हेल्ड इन इंडिया एंड समटाइम मीटिंग्स ऑफ द बोर्ड आर कॉल्ड एट अ वेरी शॉर्ट नोटिस for which there is no provision in the article of association that during such a situation notices of the meeting of the board can be sent by email. Here in the given instance such a provision in the article of association of ABC Limited is valid. XYZ लिमिटेड जो है वो एक फॉरेन कोलैबोरेटर है एबीसी लिमिटेड में. XYZ जो है वो एक फॉरेन कोलैबोरेटर है एबीसी लिमिटेड में, जो कि इनकॉर्पोरेट हुई इन इंडिया में अंडर द कंपनीज एक्ट 2013. जो फॉरेन कोलैबोरेटर है वो होल्ड कर रहा है 49% ऑफ द शेयर होल्डिंग. जो बोर्ड मीटिंग है ऑफ एबीसी लिमिटेड आर यूजुअली हेल्ड होती है इन इंडिया एंड समटाइम जो मीटिंग होती है बोर्ड आर कॉल्ड एट अ वेरी शॉर्ट नोटिस पे बुलाया जाता है फॉर विच द प्रोविजन इन द आर्टिकल ऑफ एसोसिएशन दैट ड्यूरिंग सच सिचुएशन नोटिसेस ऑफ द मीटिंग ऑफ द बोर्ड कैन बी सेंट बाय ईमेल से भेजा जा सकता है. Here in the given instance, such a provision in the article of association जो होगी of ABC Limited वो कैसी है, valid है. उसके बाद हम बात करते हैं in terms of the provision to section 173 subsection 3 of the Companies Act 2013. A meeting of the board may be called at a shorter notice. In terms of provision to section 173 subsection 3 of the Companies Act 2013, a meeting of the board जो है may be बुलाई जा सकती है at a shorter notice पर to transact the urgent business subject to the condition that at least one independent director, की at least एक independent director जो है, whether I am audible or not, I am audible, okay. At least one independent director, if any, shall be present at the meeting. No exception is made for any class and classes of a company. In terms to this proviso of section 173 subsection 3 of the Companies Act 2013, a meeting of the board may be called. मीटिंग जो है बोर्ड वाली जो है बुलाई जा सकती है. द सेम में बी कॉल्ड एट अ शॉर्टर नोटिस पर. मीटिंग ऑफ द बोर्ड में बी कॉल्ड एट अ शॉर्टर नोटिस टू ट्रांजैक्ट द अर्जेंट business subject to the condition that at least one independent director, if any, shall be present at the meeting. No exception is made for any class and classes of a company. उसके बाद हम बात कर रहे हैं कि फर्दर जो है अंडर सेक्शन 173 सबसेक्शन 3 a meeting of the board shall be called by giving not less than 7 days, by giving not less than 7 दिन से कम नहीं होने चाहिए, by giving not less than 7 days notice in writing to every director at his address registered with the company, and such office shall be sent by the hand delivery. और कैसे भेजा जा सकता है, दैट मे बी बाय हैंड डिलीवरी, बाय पोस्ट और बाय इलेक्ट्रॉनिक मीन्स. इफ वी एग्जामिन द अबाउ प्रोविजन को अगर हम एग्जामिन कर ले, इफ वी एग्जामिन द अबाउ प्रोविजन, देन इट इज एम्पली क्लियर that the notice is allowed to be sent inter alia by electronic means also. Hence, the sending of notice by email is a permissible mode of delivery and can be resorted to without any hindrance. In cases article contain such a provision, there is illegality involved even if there is a foreign collaborator in the company. Therefore, in a given case, जो shorter notice है by email वो legally permitted है, it is to be noted that there should be the presence होनी चाहिए quorum की of at least one independent director at the meeting. The provision of the article in this regard is not so relevant since the position is quite clear in the Act itself. In the order given by the NCL Enclave, New Delhi in this, Kumar Barua allies this, Ranjit Barth Kaur was held in this section 173 subsection 2 gives the right to a director of a company to participate in a board meeting through video conferencing and other audio visual means. Tribunal allow application of respondent director seeking facility of attending the board meeting through video conferencing. जो भी मम्मी पानी किसके गिर रहा है जो भी appellant director है raised apprehension that it would not be possible to ensure that no person other than the concerned director was attending the said meeting. According to the appellant secretarial standards on meeting of board of director have prescribed such option under the provision of 2013 Act and rules should be resorted to only when facility were provided by company to its director. In the instant case, company had all necessary infrastructure available here for conducting the meeting through video conferencing. It was had to follow the provision of section 173 as it would be in the interest of a company as well as the director. It would not be appropriate to shut out this provision on mere apprehension. Then आता है हमारा quorum for meeting of board section 174. Then क्या आता है हमारा quorum? What will be the quorum for meeting of board section 174? A quorum is a minimum number of directors who must attend the proceedings in order to transact business validity at a duly convened board meeting. Quorum जो है that is a minimum number of director है who must attend करना ही होगा इतने जनों को तो attend the proceeding in order to transact the business validity at a duly convened board meeting. The director must not be disqualified to participate in the meeting unless the quorum is present at the meeting. It shall not be deemed to have been properly held. Section 174 of the Companies Act 2013 contains the provision in respect of quorum required for the meetings of the Board of Directors. This provision are discussed as under. Quorum for a board meeting. What will be the quorum for a board meeting? क्या होगा? What will be the quorum for board meeting? In respect of quorum for board meeting, following points are noteworthy. The quorum for a board meeting shall be, quorum कितनी होगी? It shall be 1/3 of the total of its total strength or two director whichever is higher. It shall be either 1/3 होगी या फिर two directors होगी whichever जो भी higher होगा. तो the quorum जो होती है for the board meeting shall be या तो 1/3 होगी of its total strength, जितनी total strength है उसकी 1/3 या फिर two director whichever is higher. While calculating the quorum, any fraction of a number shall be rounded off as a 1. जब भी हम calculate करेंगे quorum तो जो भी fraction होगा of a number उसको rounded off कर देंगे हम to 1. The total strength shall not include those director whose places are vacant. Total strength में that the same shall not include those director नहीं आएंगे whose places are vacant. जो quorum है that the same need to be present throughout the meeting. जो quorum है that the same need to be present होनी चाहिए throughout the meeting. Quorum for a board meeting shall be, it shall be 1/3 of its total strength या तो वो 1/3 हो of its 1/3 होनी चाहिए of its total strength. It shall be 1/3 of its total strength या तो 1/3 होनी चाहिए या फिर two director होनी चाहिए या फिर क्या होनी चाहिए या फिर two directors होनी चाहिए whichever is जो भी higher होगी whichever is higher या तो 1/3 होनी चाहिए या तो 1/3 होनी चाहिए of its total strength या फिर two directors होनी चाहिए whichever is higher. और अगर फ्रैक्शन में तो इट इज राउंडेड ऑफ टू 1 हो जाएगा. Okay, it may be noted that the article of the company cannot specify a quorum which is less than the prescribed section 174 subsection 1. However, there is no bar in fixing a higher quorum than the required statutorily. उसके बाद modification में क्या आएगा? In a case of section 8 of company, in a case of section 8 company, section 174 subsection 1 stands modified to state that the quorum shall be either 8 member या तो quorum 8 member हो या 25% of its total strength whichever is less, provided that the quorum shall not be less than 2 members से कम नहीं होनी चाहिए. The above modification is applicable subject to the condition that Section 8 company has not committed a default in filing its financial statement under Section 137 or annual return Section 92 with the registrar. उसके बाद participation through electronic means to be counted for quorum. How there will be the participation कैसे होगा through electronic means. Participation through electronic means to be counted for quorum क्या है? The director who participate by video conferencing or other audio visual means shall be counted for the purpose of determining the quorum at the meeting unless they are to be excluded for any items of business under any provision of the act or the rules. Participation through हम क्या बोलते हैं that how there will be the participation through. How there will be the participation through electronic means to be counted for quorum. How there will be the participation through electronic means to be counted for quorum. The director who participate by video conferencing or other audio visual means shall be counted for the purpose of determining the quorum at the meeting unless they are to be excluded for any items of business under any provision of the act or the rules. How there will be the participation, हम क्या बोलते हैं, how there will be the participation through इलेक्ट्रॉनिक मीन्स. कैसे पार्टिसिपेशन होगा? थ्रू इलेक्ट्रॉनिक मीन्स विच इज टू बी काउंटेड फॉर क्वारम. जो भी डायरेक्टर है जो पार्टिसिपेट करते हैं वीडियो कॉन्फ्रेंसिंग में अदर ऑडियो विजुअल मीन्स में, दे शैल बी आल्सो बी काउंटेड फॉर द purpose of determining the quorum at the meeting unless they are to be excluded for the item of business under any provision of the act or the rules. In case when there is a vacancy in the board, अगर vacancy होती है board में, in case when there is a vacancy in the board, in case there is any अगर vacancy हो in the board, strength is less than the mentioned in the article, तो जो भी कंटिन्यूइंग डायरेक्टर है may act irrespective, वो एक्ट करेंगे irrespective of such vacancy. In case where there is a vacancy in the board, in case there is अगर any vacancy है, अगर किसी भी प्रकार की आपको लगता है vacancy है इन दी बोर्ड, स्ट्रेंथ जो है वो लेस देन है जो भी आर्टिकल में मेंशन की उससे कम है स्ट्रेंथ, तो द कंटिन्यूइंग डायरेक्टर में एक्ट इररिस्पेक्टिव ऑफ सच, तो जो डायरेक्टर है वो कंटिन्यू कर लेंगे. However, the problem will arise when due to such vacancy the number of directors is reduced below the quorum fixed by the Companies Act. प्रॉब्लम तब आ जाती है बिकॉज जितने नंबर रिक्वायर्ड है उससे कम हो रही है quorum. If in this situation the continuing director or director may act for the following purpose only and nothing else. To increase कर दीजिए the number of director to that fixed for the quorum, appoint additional director. हमें क्या करना होगा? Increase करना होगा the number of director to that fixed for the quorum, appoint करना होगा additional director को, summon करना होगा general meeting of the company. What we need to do is to summon बुलाना होगा हमें general meeting of the company. तो हमें increase करना होगा the number of director to that fixed for the quorum. हमें क्या करना होगा? इंक्रीज करना होगा. What we need to do is to increase the number of director to the fixed for the quorum. अपॉइंट करना होगा एडिशनल डायरेक्टर. हमें इंक्रीज करना होगा the number of director to that fixed for the quorum, that is अपॉइंट करना होगा एडिशनल डायरेक्टर. समन करना होगा जनरल मीटिंग ऑफ द कंपनी. quorum in case of interested director, हम क्या बोलते हैं that what will be the quorum in case of interested director, where at any time the number of interested director exceed कर जाता है is equals to 2/3 of the total strength of the board of director, the quorum shall be the number of known interested director who are present at the meeting, but their number must not be less than 2. 2 से कम नहीं होनी चाहिए. While calculating the quorum, any fraction or number shall be rounded off as 1. तो वो rounded off हो जाएगा as a 1 और as a 1. तो हम क्या बोलते हैं? quorum in case of interested director. What? How there will be the quorum in case of interested director, where at any time the number of interested director exceeds or equal to 2/3 of the total strength of the board of director, the quorum shall be the number of known interested director who are present at the meeting, but their number must not be less than 2. While calculating the quorum, any fraction or number shall be rounded off as 1. Then comes the meeting of there will be director. How there will be the meeting of interested director? So term है interested director for the purpose of section 174 subsection 3 means a director within the meaning of section 184 subsection 2. According to section 184 subsection 2, interested director मतलब होता है means every director of a company who is in any way whether directly indirectly concerned or interested in a contract or arrangement in proposed contract or arrangement enter into or to be entered into with the body corporate in such a director in association with any director hold करे है more than 2%. if they are holding more than 2%, more than हम क्या बोल रहे हैं? more than 2% शेयर होल्डिंग of that body corporate is a promoter manager chief executive officer of the body corporate. उसके बाद आ रहा है हमारा with the firm or other entity in which such director is a partner, owner or member as the case may be. In case of private company which has not committed a default in filing its financial statement, हम क्या बोलते हैं that in case of a private company, in case of a private company which has not committed, जिसने default नहीं किया है in filing its financial statement under section 137, annual return under section 92 with the registrar, the provision of section 174 subsection 3 shall apply with the exception that the interested director may participate in such a meeting after disclosure of his interest pursuant to this section. Then आता है हमारा adjournment of meeting which could not held for want of quorum. As we have noticed that board meeting cannot be validly held if there is no quorum present. Thus, where a meeting of the board could not be held for want of quorum, then unless the articles of the company otherwise provide, the meeting shall automatically stand adjourned to the same day, at the same time and place in the next week, or if that day is a national holiday, till the next succeeding day which is not a national holiday at the same time and place. Adjournment कैसे, adjournment मतलब postpone होने वाली है, adjourn meeting नहीं हो पाई and all such thing. The adjournment of meeting which could not be held for want of quorum, मतलब want quorum नहीं थी इस वजह से वो postponed हो गई है, आगे मतलब आगे further कभी होगी ऐसा. As we have noticed that the board meeting cannot be validly held if there is, जैसे कि हमें पता है, we have noticed that अगर बोर्ड मीटिंग कैन नॉट बी वैलिडली हेल्ड, अगर वो वैलिडली नहीं हो पाई है, इफ देयर इज नो quorum, quorum प्रेजेंट नहीं थी, thus where the meeting of the board could not be held for want of quorum की वजह से नहीं हो पाई है, then unless the article of the company otherwise provide, the meeting shall automatically stand adjourn हो जाएगी to the same day at the same time, adjourn हो जाएगी to the same day same time place in the next week, or if that day is a national holiday till the next succeeding day, अगर national holiday है तो next succeeding day पे which is not a national holiday at the same time and place. Then आएगा exemption to OPC. What will be the exemption to OPC? क्या होगा? According to proviso to section 173 subsection 5, जो भी provision है section 174 का जो कि relating है to the quorum, वो applicable नहीं है to one person company पे. quorum वाला provision applicable नहीं है which has only one director on its board. एक ही director है उसमें, क्या हम quorum का provision लगाएंगे and all such thing. Now do this example as well. There are 9 directors in a company. हम क्या बोल रहे हैं कि 9 directors हैं, इसी के लिए discharge होने वाला है, तो what I need to do is to charge it. We are continuing the things from which example? If I'm not wrong, then example number 4. Okay. Alright, so we are continuing the thing hereby and example number 4. Example number 4 जो है वो बोलता है कि there are 9 directors in a company and out of which 2 offices of the director have fallen vacant. 9 directors है कंपनी में and out of which 2 offices जो है of director के the same have fallen vacant. According to section 174 subsection 1 of the Companies Act 2013, quorum is 1/3 of the total strength of the board. अगर 9 director है out of which 2 offices of the director have been fallen. There are हम क्या बोल रहे हैं that there are 9 directors है हम क्या बोलते हैं that there are 9 directors है in a company and out of which 2 offices of the director have fallen vacant. 2 offices जो है director के the same have fallen वो vacant हो चुके हैं. According to section 174 subsection 1 of the Companies Act 2013, quorum is 1/3 of the total strength. quorum क्या होगा? It will be 1/3 होगी या तो 1/3 होगा total strength का. Any fraction contained in the set 1/3 being rounded off, 1/3 को rounded off कर दिया जाएगा as a 1 और या फिर 2 director. quorum या तो 1/3 होगा of the total strength का of the total strength या फिर कितने होंगे 2 directors होंगे जो भी उनमें से higher होंगे whichever is higher. जो total strength है that is to be derived after deducting the number of director whose offices are vacant. Therefore, where the total number of director is 9, 2 offices of the director have fallen vacant. Total strength comes to 7. 2 वैकेंट है यानी कि 7 हो गए. 9 minus 2 7. 7 का 1/3 कितना होगा? 7 का 1/3 हो जाएगा. इट विल बी नियर टू 2.33. 2.33 हो जाएगा which will be rounded off to 3. So either 3 or 2 whichever is higher. So therefore 3 director would constitute a quorum for the board meeting here. तो यहाँ पे कितने जने जो quorum बनाएंगे यहाँ पे जो quorum बनाएंगे वो हो जाएगा 3. Okay. Now, if suppose there are total 15 directors in a company during the discussion on a particular 13 of the director happen to be interested है 13 ही interested है उसमें से Section 184 subsection 2 of the Companies Act under Section 174 subsection 3 of the Companies Act 2013. If at any time the number of the interested director exceeds or is equals to 2/3 or total strength of the board of the number of the director who are not interested but present at the meeting, not two shall constitute the quorum. तो in the given case में क्या होगा? There are total 15 directors and the board meeting commences with all of them. During the meeting, an item comes up for discussion in respect of which 13 directors happen to be interested directors. In spite of the fact that the interested directors are more than 2/3, minimum 2 not interested directors who are present at the meeting shall constitute the quorum and they can validly transact that particular business in view of this. तो इसमें क्या बोल रहे हैं हम? In the given case, अगर total 15 directors है and the board meeting commences with all of them. During the meeting, an item comes up for discussion in respect of which 13 director happen to be interested director. जिसमें से 13 ही interested है. In spite of the fact that the interested director are more than 2/3 of the minimum 2 non-interested director who are present at the meeting shall constitute the quorum and they can validly transact the particular item of the business. इसका क्या मतलब है? इसको further हम पढ़ते हैं. Then comes a meeting held of the board of No Holiday Limited was held on a holiday on account of Ganesh Chaturthi. Meeting जो है वो of No Holiday Limited एक कंपनी है but उसमें जो meeting है वो गणेश चतुर्थी पे रखी जा रही है. However, due to lack of quorum, the proceeding of the meeting could not be held and therefore the chairman of the meeting with the consent of majority decided that the board meeting adjourned to next week on the same day. However, the date fixed for the adjourned meeting happened to be a Sunday हो गया उस दिन भी. In such a case where a board meeting is adjourned due to lack of quorum, then under section 174 subsection 4 जो भी adjourned meeting है that the same can be held on the same day at the same place in the next week or if that is a national holiday till the next succeeding day which is not a national holiday at the same time place unless the article provides otherwise. Since this exclusion of only national holiday, any original adjourned committee meeting can be held on Sunday and other holiday. In view of this provision, the adjourned meeting on the board no holiday can be held on Sunday without involvement of any illegality. तो नेशनल हॉलिडे का एक्सक्लूशन किया है संडे को होती है. Then हाई कोर्ट जो है of Andhra Pradesh in the Srimati This Renuka Biological E Limited is an appeal held that where with the resignation of one director, number of director fall below minimum number of two as prescribed under section 174. Subsequent board meeting convened and conducted by the said director by his withdrawal of resignation was patently illegal and consequently further appointments of director in such meeting were also illegal and known this. In the said case, 3-person constituted board of director of company, one of director died. Another director R5 submitted resignation from directorship and thus only one director was left on board. However, R5 withdrew his resignation and on the same day called upon a board meeting. Whether with resignation of R5 as a director, company failed to satisfy mandatory provision of section 174 of having at least two directors with resignation of R5 coming into force with immediate effect as desired by him. Had no authority to convene any board meeting, it was held at meeting of board of meeting could not be said validly held. Thus, appointment of new director in said meeting was also invalid. Passing of resolution by circulation section 175. Passing of resolution by circulation section 175 क्या बोलता है? Section 175 of the Act and the Rule 5 of the Companies Meeting of Board and its Power Rule 2014 contain the provision for passing of resolution by circulation. Normally, a board meeting is conducted to pass resolution. There are certain matters which, according to the provision of the Companies Act 2013, can only be considered and decided at the duly convened board meeting, and therefore they cannot be implemented through passing resolution by circulation. However, in cases where the matter is not that much important and therefore does not require its consideration at a board meeting, though consent of director is required to implement that the matter or the calling of board meeting is lengthy and costly affair, keeping in view the urgent implementation of certain decisions, the company may, in respect of such a matter, resort to passing a resolution by calculation. As a matter of fact, all such matters which do not require consideration at a board meeting can be decided through resolution which are passed by circulation. जो भी provision है section 175 and the rule 5 are discussed here under. What will be the requirement to pass the resolution by circulation? A resolution shall be deemed to have been duly passed किया जाएगा by the board or by the committee, therefore by in circulation in case the resolution has been circulated in draft together with necessary papers, if any, to all the directors or members of the committee as the case may be. At their addresses registered with the company in India by hand delivery or by post or by courier or through such electronic means as may be prescribed, and has been approved by majority of directors or members who are entitled to vote on the resolution. Rule 5 provides that a resolution in draft form may be circulated to the directors together with their necessary papers for seeking their approval by electronic means, which may include the email or fax. When a resolution cannot be passed by circulation, अगर resolution जो है उसे pass नहीं किया गया करवाया गया by the circulation, if at least 1/3 of the total number of directors of the company for the time being required at any resolution under circulation must be decided at a meeting, the chairperson shall put the resolution to be decided at a meeting of board instead of being decided by circulation. Noting of past resolution in next meeting. A resolution that has been passed by circulation shall have to be necessarily noted in the next meeting of the board or the committee thereof, as the case may be, and made part of the minutes of such meeting. In respect of certain matter which did not require to be decided at a board meeting, PKR Limited thought it prudent to pass resolution thereof by circulation. Accordingly, a draft resolution was circulated among all of the 6 directors by email. 3 directors did not give their consent and desired that the resolution was required to be decided at a meeting. उसके बाद, in the light of provision of section 175 subsection 1, where the minimum 1/3 of the total number of directors required at any resolution under circulation must be decided at a meeting, the chairperson shall put the resolution to be decided at a meeting of the board. In the given case, 1/2 of the total number of directors, 3 out of 6, requires that the resolution must be decided at a board meeting. Since their counting is more than 1/3 of the total strength, the chairperson need to take the call and put the resolution to be decided at a duly convened meeting of the board. Then आता है हमारा Audit Committee Vigil Mechanism and Punishment section 177 and section 178 subsection 8. Audit Committee क्या बोलती है? Section 177 of the Act and Rule 6 and 6A of the Companies Meeting of Board and its Power Rule 2014 It contains the provision in respect of audit committee. ये जो provision है, these are described as under. Company required to constitute an audit committee, section 177 and rule 6. Following companies are required to constitute an audit committee. Every listed public company, every listed, हम क्या बोलते हैं, that every listed public company having the जिसकी paid up share capital है 10 करोड़ या उससे ज्यादा, हम क्या बोलते हैं, जितनी भी एवरी लिस्टेड पब्लिक कंपनीज है या पब्लिक कंपनी जिसकी पेड अप शेयर कैपिटल जो है वो 10 करोड़ या फिर उससे ज्यादा है, 10 करोड़ या उससे ज्यादा है, पब्लिक कंपनी हैविंग द टर्नओवर जो है वो उसका 100 करोड़ या उससे ज्यादा है, पब्लिक कंपनी विच एग्रीगेट आउटस्टैंडिंग, हम क्या बोलते हैं, आउटस्टैंडिंग लोन्स डिबेंचर 50 करोड़ या उससे ज्यादा है. The public company stated at this point B, C and D are the classes of companies which are prescribed by Rule 6 of the Companies Meeting of Board and its Power Rule 2014 and are required to constitute an audit committee. In fact, Rule 6 required that the company prescribed in Rule 4 of the Company's Appointment and Qualification of Director Rule 2014 at the company which shall constitute an audit committee. Audit committee shall be constituted by the BOD. कौन कंस्टिट्यूट करेगा ऑडिट कमेटी को? बोर्ड ऑफ डायरेक्टर्स. एवरी लिस्टेड पब्लिक कंपनीज, अदर क्लास और क्लासेस ऑफ द पब्लिक कंपनी हैविंग जिसकी पेड अप शेयर कैपिटल हो 10 करोड़, टर्नओवर मतलब 10, 10 और 50, सॉरी 10 सबसे कम क्या होता है, पेड अप शेयर कैपिटल, टर्नओवर हमेशा ज्यादा होता है, दैट इज 100 करोड़, और आउटस्टैंडिंग समवेयर लाइज बिटवीन द पेड अप शेयर कैपिटल और टर्नओवर, जो इसके बीच में है, जो कि क्या है 50 करोड़ और मोर. तो हम क्या बोलते हैं, ऑडिट कमेटी शैल बी कंस्टिट्यूटेड, बीओडी बनाएगा. एवरी लिस्टेड कंपनी की तो हर वाले केस में ऑडिट कमेटी बनेगी. अगर अदर क्लास ऑफ अदर पब्लिक कंपनीज है जिसकी पेड अप शेयर कैपिटल 10 करोड़ या उससे ज्यादा है, टर्नओवर 100 करोड़ या उससे ज्यादा है, आउटस्टैंडिंग लोन बोरिंग्स 50 करोड़ या उससे ज्यादा है, company not required to constitute an audit committee. Following unlisted public company are not covered in this Companies Act. Appointment and qualification of director rule 2014 therefore are not required to constitute an audit committee. बनाने की जरूरत नहीं है. उसके बाद हम बोलते हैं कि a joint venture, a wholly owned subsidiary, a dormant company as defined under section 455 of the Act. When a company ceases to constitute an audit committee, a company which was obligated to constitute an audit committee shall not be required to constitute such audit committee. If it ceases to fulfill any of the three conditions relating to paid up share capital or turnover or outstanding loan in the third proviso for 3 consecutive years, it shall again be required to constitute an audit committee if it start the meeting of any of such conditions. उसके बाद क्लैरिफिकेशन के एक्सप्लेनेशन टू दिस क्लैरिफाई दैट जो भी पेड अप शेयर कैपिटल होगी, टर्नओवर होगी, आउटस्टैंडिंग लोन डिबेंचर डिपॉजिट होगा, एज अ केस में बी एज ऑन द एग्जिस्टिंग लास्ट डेट ऑफ लास्ट ऑडिटेड फाइनेंशियल स्टेटमेंट शेल बी टेकन इनटू अकाउंट. Composition of how there will be the composition of audit committee section according to section 177 जो भी audit committee होगी shall consist of minimum 3 डायरेक्टर होंगे. इसमें क्या होगा, it shall consist of minimum 3 डायरेक्टर होंगे audit committee में with independent director forming the majority. Further it is required जो majority होगा of members of the audit committee including its chairperson shall be the person with the ability to read and understand the financial statement. उसके बाद व्हाट विल बी द डिस्क्लोजर ऑफ कंपोजिशन ऑफ ऑडिट कमेटी, जो भी बोर्ड रिपोर्ट होगी अंडर सेक्शन 174 आई मीन अंडर सेक्शन 134 शैल डिस्क्लोज करेगी द कंपोजिशन ऑफ एन ऑडिट कमेटी. In case where the board has not accepted any recommendation of the audit committee, the same shall be disclosed in the board report along with the reason thereof. Then comes the responsibility of the audit committee. According to section 177, every audit committee shall act in accordance with the terms of reference specified in writing by the board, shall inter alia include the recommendation for appointment, remuneration and terms of appointment of auditors of the company. In case of a government company which has not committed a default in filing its financial statement under section 137 and annual return under section 92 with the registrar for the words recommendation for appointment, remuneration and terms of appointment used in this section, the word recommendation for remuneration shall be substitution dated in this. Review करेंगे, monitor करेंगे the auditor independence and performance and effectiveness of the audit process. एग्जामिनेशन किया जाएगा फाइनेंशियल स्टेटमेंट का एंड द ऑडिटर्स रिपोर्ट देयर ऑन. अप्रूवल होगा ऑफ एनी सब्सिक्वेंट मॉडिफिकेशन एंड ट्रांजैक्शन ऑफ द कंपनी विद रिलेटेड पार्टी एंड द प्रोविजन ऑफ डिस्क्लोजर स्टेटेड बिलो. उसके बाद क्या आता है, उसके बाद देन देयर कम्स द देन हमारा आता है देन देयर कम्स द रिव्यू एंड मॉनिटर द ऑडिटर्स इंडिपेंडेंस एंड परफॉर्मेंस एंड इफेक्टिवनेस ऑफ ऑडिट प्रोसेस। कैसे हम एग्जामिनेशन करेंगे फाइनेंशियल स्टेटमेंट्स का, ऑडिट रिपोर्ट का, देन अप्रूवल ऑफ और एनी सब्सिक्वेंट मॉडिफिकेशन एंड ट्रांजैक्शन ऑफ द कंपनी विद रिलेटेड पार्टी, द प्रोविजन ऑफ दिस क्लूज एज स्टेटेड बिलो। व्हाट विल बी द ऑमनीबस अप्रूवल? ऑमनीबस अप्रूवल क्या होगा? इट इज प्रोवाइडेड दैट जो भी ऑडिट कमेटी होगी मे मेक ऑमनीबस अप्रूवल for related party transaction proposed to be entered into by the company subject to such a condition as prescribed in rule 6A, refer the books below. What will be the condition? कौन सी ऐसी condition होगी जो कि prescribe होगी? rule 6A of the company's meeting of board and its power rule 2014 for omnibus approval for related party transaction on annual basis. अकॉर्डिंग टू रूल 6 बोलता है जितनी भी रिलेटेड पार्टी ट्रांजैक्शन है दे शेल रिक्वायर अप्रूवल ऑफ द ऑडिट कमेटी। जो भी ऑडिट कमेटी है दे मेक द ऑमनीबस अप्रूवल फॉर रिलेटेड पार्टी ट्रांजैक्शन प्रपोज टू बी एंटर्ड इनटू बाय द कंपनी सब्जेक्ट टू द फॉलोइंग कंडीशन। जो भी ऑडिट कमेटी है शेल आफ्टर ऑब्टेनिंग द अप्रूवल ऑफ द बोर्ड ऑफ डायरेक्टर्स स्पेसिफाई द क्राइटेरिया फॉर मेकिंग द ऑमनीबस अप्रूवल व्हिच शेल इंक्लूड द फॉलोइंग। व्हाट विल बी द मैक्सिमम वैल्यू? क्या होगी ट्रांजैक्शन की? हम क्या बोलते हैं दैट व्हाट विल बी द मैक्सिमम वैल्यू? Maximum value क्या होगी transaction in aggregate which can be allowed under the omnibus route in a year. What will be the maximum value per transaction which can be allowed? Extent and manner of disclosure to be made to the audit committee at the time of seeking omnibus approval. Review at such interval as audit committee may deem fit related party transaction entered into by the company pursuant to each of the omnibus approval made. Transaction which cannot be subject to omnibus approval by the audit committee. What all will be the transaction which cannot be subject to omnibus approval by the audit committee? तो ऑडिट कमिटी जो है वो कंसिडर करेगी फॉलोइंग फैक्टर्स व्हाइल स्पेसिफाइंग द क्राइटेरिया फॉर मेकिंग द ऑमनिबस अप्रूवल के लिए। उसके बाद आता है कि रिपीटेटिवनेस। व्हाट विल बी द रिपीटेटिवनेस? क्या होगा? ट्रांजैक्शन इन पास्ट और इन फ्यूचर। जस्टिफिकेशन क्या होगा? फॉर नीड ऑफ द ऑमनिबस अप्रूवल। जो भी ऑडिट कमेटी होगी दैट द सेम शैल सैटिस्फाई इटसेल्फ ऑन द नीड फॉर ऑमनिबस अप्रूवल फॉर ट्रांजैक्शन ऑफ रिपीटेटिव नेचर एंड दैट सच अप्रूवल इज इन द इंटरेस्ट ऑफ द कंपनी। जो भी ऑमनिबस अप्रूवल होगी दैट शैल कंटेन एंड इंडिकेट द फॉलोइंग। क्या इंडिकेट करेगी? दैट नेम क्या है रिलेटेड पार्टी का, व्हाट विल बी द नेचर एंड ड्यूरेशन ऑफ द ट्रांजैक्शन क्या है, व्हाट विल बी द मैक्सिमम अमाउंट ऑफ ट्रांजैक्शन दैट कैन बी एंटर इनटू, इंडिकेट द बेस प्राइस और करंट कॉन्ट्रैक्टेड प्राइस एंड द फॉर्मूला फॉर वेरिएशन इन प्राइस इफ एनी अदर इंफॉर्मेशन जो कि रेलेवेंट है, इंपॉर्टेंट है ऑडिट कमेटी के लिए एंड टेक अ डिसीजन ऑन द प्रपोजल ट्रांजैक्शन। However, where the need for related party transaction cannot be foreseen and aforesaid detail are not available, audit committee may make the omnibus approval for such a transaction subject to their value not exceeding the rupee 1 crore per transaction. उसके बाद जो भी omnibus approval होगी that shall be valid होगी for a period not exceeding 1 financial year and shall require fresh approval after the expiry of such financial year. Omnibus approval shall not be made for transaction in respect of selling and disposing of the undertaking of the company. Any other condition as the audit committee may deem fit. If no approval accorded, अगर कोई भी approval accorded नहीं है तो it is further provided that in case of transaction which is not a transaction referred to in section 188 where audit committee does not approve such a transaction, it shall make its recommendation to the board. Voidable transaction. In case of transaction which does not involve an amount exceeding 1 crore rupee and which is entered into by the director or officer of the company without obtaining the approval of the audit committee and it is not ratified by the audit committee within 3 months from the date of transaction, such a transaction shall be voidable at the option of the audit committee within 3 months from the date of transaction. Such a transaction shall be voidable at the option of the audit committee. In case such a transaction is with the related party or any director or is authorized by any other director, the director consent shall indemnify the company against any loss incurred by it. Then comes that what will be the known applicability to a transaction between a holding and its wholly owned subsidiary company. Known applicability क्या होगी? What will be the known applicability?